You may recall, Chair, that Minister Alan Shatter, when he was Minister for Justice, received information from Commissioner Callan about Mick Wallace and a road traffic offence at the Five Lamps in Dublin, which was deemed to be pretty close to political policing. But the specific question that I would have relates to an incident in August 2020, when the then EU Commissioner Phil Hogan was cautioned for using a mobile phone at the time that he was having a bit of a dispute with the government. Now, he wasn't caught with a bag of Kalashnikovs in the boot, or there was no great threat to state security or anything like that. He was caught with a mobile phone in his hand. So I suppose I'd ask if the Commissioner might outline, so that we could understand what we're legislating for. We were subsequently told, of course, that the Commissioner brought this to the Minister for Justice's attention. She brought it to Cabinet, and the Cabinet duly used it to get rid of a Commissioner that they were under political pressure to get rid of to save their own hides. So I suppose I'd ask the Commissioner, why, in his opinion, why did he form the opinion, or on what basis did he form the opinion that this information about somebody holding a mobile phone, which, of course, every offence is potentially serious, but carrying a mobile phone for which you received a caution is perhaps not the most serious criminal offence, and certainly not even the most serious road traffic offence. So on what basis did he form the opinion that this information should be brought to the Minister for Justice?
I'm afraid I don't enjoy the same privilege in being able to answer this question that Mr. McNamara enjoys in asking the question of me. One of the principles of the Section 41 reports to the Minister is only the Minister can make a decision in terms of the publication of such a report, and that's in the present legislation, and in effect explicitly prevents me from talking or going into any of the detail in respect of that. And I think actually that question is actually beyond my remit in these circumstances to answer. Thank you.
I'd ask the Commissioner, does he think that more detail might be beneficial in the legislation over what should be brought to the Minister's attention? I mean, obviously, matters pertaining to the preservation of peace and public order, the protection of life and property, the protection of the security of the state, I mean, that's all very clear. But then this omnibus thing that enables him to basically, I'm not saying he did or would, but that would enable future commissioners to provide sensitive private information about somebody that a member of the government was in a political dispute with. I mean, that's sort of more Zimbabwe than Phoenix Park, but we can never take anything for granted.
No, and you're entirely correct to say that we abide entirely by the rule of law, and the rule of law as it applies in the 2005 Act and the Section 41 referrals. So in the abstract, this power is used in conjunction with our responsibilities under Section 7 of the Garda Commissioner Act and connected to our policing functions. Anything which is provided to the Minister is in respect of our policing and security functions, and not in any form gossip or tittle-tattle or anything remotely to a political advantage. And I'll give you full assurance in respect of that. It's tied closely to our policing function.